you. So, Rachel's had us in Brussels. I'm going to take you back to the UK, back to London, back to Cardiff, back to Edinburgh as well, briefly. So, here's a review of some of the key legal developments over the last 6 months. And we'll start with the big event that didn't happen. We didn't leave on the 29th of March 2019. That 2-year period that was set out, that is set out in Article 50, that is the way that we are to negotiate our departure from the EU. It sets a 2-year period for negotiations. That came to an end 29th of March. We saw quite a lot of frenzied activity running up to that date when it looked as though that's when we're going. And then it didn't happen. 12th of April, there was an extension, right, and then a further extension was agreed, because it has to be agreement between the UK and the EU to these extensions, an extension to the 31st of October. And on the EU side, we heard, the idea is there is no revision to the agreement, and we should be getting on with putting our house in order to make sure that we can leave on the 31st of October, and that we have the legal framework in place within the UK to make that possible. So, where we are, as things stand, we've heard the UK will leave on the 31st of October unless, perhaps a little unlikely, the first one, we've already agreed the withdrawal agreement, that it's gone through all the processes domestically that need to be done before that. It's ratified, it's implemented, the law is in place. I think that's fairly unlikely. Unless there is a new extension that is agreed between the two sides. And I don't think the EU, as we've heard, is going to just put up with request after request to extend, unless it's very clear that that time is needed for sort of technical purposes to get this agreement finalised in law domestically. Or the UK revokes its notification, perhaps following a further referendum. So if none of those things have come to pass, then the UK will be leaving on the 31st of October, either, as we've heard, with a deal or without a deal. And if it's with a deal, if we have reached an agreement, then there will need to be the legal translation of all of that into UK law. We have a piece of legislation from last year. This time last year, it was being put into law. It got royal assent this time last year, the EU Withdrawal Act. That is the key piece of legislation that sets out how EU law is going to start taking effect as UK law, how we're going to make that transition internally within the UK. And that sets out a process for departure within that legislation. And it sort of sets out Section 13. There has to be a meaningful vote. Now, we've seen there have been a number of meaningful votes that didn't necessarily bring the meaning that some wished they had. Anyway, so we've got the meaningful vote. So we'll need to have that, and we'd also have to have a new piece of legislation putting the withdrawal agreement into law. So a withdrawal agreement bill. So that would have to all be in place, and in terms of the things that we need to be securing into domestic law to make these enforceable within national law. So we'd need to provide for that transition period, that the law is there and can be used as EU law, as domestic law, for a transition period. Also provide for the citizens' rights, that part of the agreement at the moment about the rights of EU citizens here in the UK, that makes that an enforceable reality, that you can go to the courts and enforce these commitments. So these need to be written in to domestic law. So all of those things would have to be put into domestic law. Or, if that's not done, and we've got no extension to time, the UK will be out and we're in a no-deal scenario once more. And that frenzied period that we've seen before, how much of it will feel like March? That March where there was that very sort of frenzied activity in some quarters. Will the UK be any better prepared come October? Again, sort of this time last year, what sorts of actions, what sort of activities were underway? Well, we saw the Civil Contingencies Secretariat, that's part of the Cabinet Office, that began preparing for no deal. Operation Yellowhammer is the name it goes by, and it saw it working very closely with the devolved governments and with local resilience forums, identified 12 core areas of risk, such as food and water supplies, risks to that, risks to the banking infrastructure, risks to national security. So there's this job of work that's been going on there. And to some extent, obviously, the pressure is being released a little from that. Businesses, civil society, for some, a big investment in that March date. They may now be thinking, perhaps we won't make the same sort of commitment of time and resources when it comes around in October, because it might have felt somewhat wasted to prepare for that no-deal eventuality. They may be less inclined to make those steps. So it's not clear how much more prepared in practical terms we may be. But in legal terms, in terms of the preparations as far as the framework for applicable laws, there was a very significant amount of work done. A lot had been achieved and was in place in time for March. Perhaps not everything, but there was a lot there. And as I said, the EU Withdrawal Act is that key piece of legislation which is the route in for these things to take place within the UK legal order. The key thing that it does, that Withdrawal Act, is it repeals a piece of legislation from back in the 1970s that we had to pass when the UK joined the EU to give EU law its force within the UK. Otherwise, it's just noise. It's just out there and it's noise. It needs this piece because of parliamentary sovereignty. It needs a piece of UK parliamentary law to turn it on. And that's the European Communities Act from 1972. And what the Withdrawal Act does is it turns it off. But we've got all this law, so what are we going to do with it? Rather than just having a big black hole that everything falls into, we convert it into domestic law, retained EU law, and that's what the Withdrawal Act does. So the Withdrawal Act is law, but it hasn't turned off the European Communities Act yet. So little bits of the law can come in at different times. But we are having this process of converting law and also giving powers to ministers to make amendments to existing law, to that retained law, to make it workable. And we've seen a lot of activity there. There's been a lot of use. One of the things that if you've been to any of our previous roadshows on Brexit that you might have, that Withdrawal Act was very controversial because it tried to do, or initially it was sort of reaching into devolved areas. And initially it was saying everything that falls within devolved competence, agriculture, environment, health, that's coming back to Westminster, and then we're going to decide whether it can be packaged back out. That was the initial starting point. The place where the legislation ended up was to say, no, powers go back to where they lie under the devolution settlements, but potentially ministers, UK ministers, can freeze the law in devolved areas with the intention of making new UK-wide frameworks. So the legislation has this freezing power. That hasn't been used yet. There was a lot of concern, there was a lot of criticism around that, but that particular power has not yet been used. But as I say, we've seen a lot of statutory instruments, a lot of secondary legislation being adopted that applies both across the UK as a whole, but we also have powers for Welsh ministers to introduce their own statutory instruments in devolved areas, making necessary technical amendments to the law to make it work. So in the past, where you have to report to the Commission, well, you're not going to be able to report things to the Commission anymore, so you need to create new institutions, new actors, policy actors, to be able to play a part in this. So we've got statutory instruments, regulations that might be adopted by Welsh ministers. Also, you've got regulations being adopted by UK ministers, sometimes recognising, but we'll only go up to the border there, and then the Welsh ministers can do that bit for Wales. But sometimes, given the enormous job of work, these regulations have been made in London for the whole UK, or for England and Wales. And so there's roughly sort of 500, 550 statutory instruments that have been adopted by UK ministers. And a number of these have that reach into devolved areas of competence, so they apply for Wales. But the idea very much is, following an agreement that was reached, the intergovernmental agreement that was reached last year, this will be done with consent. Now, so the consent of the Welsh Government to these measures. So a lot of that had been done, a lot of that is in place. Where we are now looking forward to October is some of those already need updating because the law's already changed. Some of these, we know, because it was being done so quickly, contained errors, contained defaults in some ways, and so they need re-adopting. So there's a job of work being done there. There's also concerns as well about the use of these by UK ministers in devolved areas, that sometimes, particularly the CLAC, the Constitutional and Legislative Affairs Committee from the Assembly, has said, no, this is eating into devolved competence, that they've seen incidents where the exercise of these powers by UK ministers hasn't been appropriate. And some of the sort of standout issues, there's sort of disagreements about where competence lies. Is it reserved? Is it devolved? So state aid is a key example where UK ministers want to make the regulations and they weren't accepting that this was a devolved area. And also some sort of suggested sort of trimming of devolved competence in the exercise of those powers. Anyway, we've got that body of work, that body of legislation, of secondary legislation that's in place. Running alongside that, primary legislation, so now Acts of Parliament. And it was suggested there'd be sort of 9 or 10 of these that were going to be necessary to have in place for the UK's withdrawal. And we're still at a position where a large number of those haven't been adopted. Some of them are sort of stuck in the system, some of the bigger, more controversial pieces of legislation. The only one that we've seen adopted in the last 6 months is the healthcare one. Reciprocal arrangements. Currently, as an EU citizen, you have a right to have reciprocal access to healthcare in any other member state and in EEA states. And so setting out the framework for what happens when you no longer have those EU citizens' rights to that healthcare, and giving powers to ministers to put in place any agreements that are made around reciprocal healthcare. So that Act of Parliament has gone through. And it has a clear devolution dimension because healthcare is devolved. And what we do see with this piece of legislation is it's another one that's come a long way from its initial starting point, just like the Withdrawal Act itself, that they started in a fairly sort of tone-deaf way in terms of devolution, that devolution dimension simply wasn't acknowledged or wasn't sufficiently acknowledged in the first iterations of that legislation. But the piece of legislation that we have there now is sort of it's a sort of a tighter piece of law. It puts more constraints on what ministers can do. So these are UK ministers. And if they are adopting measures that do intersect with devolved competences, then they have to do it in consultation with the devolved administration. So that's now on the face of the legislation, and it wasn't there before. This brings up legislative consent. The situation where the Parliament and the Assembly, the Parliament in Scotland, the Assembly here, if Westminster is legislating in an area that is devolved, usually, under the Sewell Convention, Westminster will not normally do that. They will respect the devolution dimension. They will not normally legislate on these things, except where they have consent. So when they've got the consent of the Assembly or they've got the consent of the Scottish Parliament to say, yes, you can legislate for us in this area. The Sewell Convention. Last year with the Withdrawal Act, Scotland, the Scottish Parliament, would not give its consent to the Withdrawal Act. And it's now adopted a position, or the government has adopted a position to say, don't come to us for consent. They're saying, we will only consider it in exceptional circumstances. So that's the government, the Scottish Government's position. But we do see the Scottish Parliament, well, in this particular case, they said, no, this is one of those exceptional circumstances, and we will consider giving legislative consent. The Welsh Assembly, it had 2 different consent motions here, and also entered into a new memorandum of understanding. So you're seeing a real sense of the Welsh Government working with the UK government and taking a rather different position from Scotland, which is a rather more conflictual position. but ultimately ending up in the same place as far as the piece of law at the end and its effects, but a different political take on it. Finally, just a couple of words about common frameworks. And these common frameworks were what were in mind when those provisions were written into the Withdrawal Act about freezing powers, freezing devolved competence. Looking ahead to saying there are going to be some things that are currently handled through EU law that sets a framework for the whole UK and the whole EU, allows some kind of difference and diversity within it, but generally, we've got a common approach, whether that's in agriculture, agricultural funding, whether that's environmental protection. But that once you take that common approach away, then if it's devolved, you've got a potential for 4 different approaches across the UK. Perhaps 4 very different approaches across the UK. And the sense of these common frameworks is recognising that sometimes it makes sense to work together. And so this was what was in mind with that sort of freezing power. And these common frameworks, when we see them, we may be seeing them come through UK-wide legislation, we may see them come through coordination through the different parts of the UK, making their own rules, but through a coordinated, agreed approach. It may be that the secondary and primary legislation we've seen already might form some of those common frameworks. But just to draw back, what we haven't seen, as I said, we haven't seen that freezing power yet. That what was seen as very controversial and was one of the reasons Scotland couldn't give its support to the legislation, the Withdrawal Act. Now, it's not been needed yet. It's not been necessary yet because we're still bound by EU law. But I think looking ahead in terms of what might happen in the next 6 months, that we may see the emergence of a lot more tension coming through here. Because if we do leave and without a deal and we're no longer bound by that EU framework, then the potential for different approaches to take place can emerge. And so the need for the freeze comes in. And so we might see sort of tensions and flashpoints around that. And we may see sort of flashpoints as well around politically disagreements about whether or not a common approach is needed. And so we might see some of a separating of the ways, particularly between Wales and Scotland. Okay. Thank you.